I take great pains to tell you that the decision of the Court of First Instance on this matter utterly fails far short of expectation. I am therefore here to tell you that though the judgment of the court yesterday is respected, it is a judgment that I refuse to accept. I refuse to accept the judgment because I believe that it is bereft of substantial justice. However, the disappointment in the verdict of the court can never destroy my confidence in the judiciary. Consequently, I have asked my lawyers to activate my constitutionally guaranteed rights of appeal to the higher court, which in the instance is the Supreme Court of Nigeria. Whether I prevail in this quest or not, the record of my effort in ensuring an order of credible elections in Nigeria shall remain for the future generations to emulate.
It is my intention as the presidential candidate and intention of Labour Party to challenge this judgment by way of appeal immediately as allowed by the Constitution of Federal Republic of Nigeria. The PEPC has rendered its judgment, but that esteemed body is not the final arbiter. The responsibility now falls on the Supreme Court. I do know that the judgment is not conterminous with justice. I implore Nigerians to remain focused, steadfast, and peaceful, and to abide by the rule of law and understand this matter has not reached its logical conclusion. Our legal team has already received our firm instruction to file an appeal against the decision. I shall not relent in quest for justice, not necessarily for myself, but for indeed for our teeming supporters all over Nigeria, whose mandate to us at the post was regrettably truncated by INEC. The strength and value of our democracy reside on solid national institutions, and our confidence in them. Electoral litigations will almost be unnecessary and non-existent if the Independent National Electoral Commission discharges its statutory functions creditably, transparently, and with sustainable fairness.
All right, welcome back. So that is what we'll be talking about today. Reactions from that presidential election petition court's judgment, of which you heard the parties in question saying they are going upstairs. We've got some gentlemen joining us here in the studio to discuss this matter. Mr. Adebayo Shitu is the former Attorney General and Commissioner for Justice for your state, also former Minister of Communications. And then sitting beside him, Professor Maxwell Gidado, a senior advocate of Nigeria. Gentlemen, good morning. Thank you for coming on today.
Thank you. Morning.
Yes, but we will have another guest, but when he joins in, we will introduce him. Mr. Shitu, you've heard responses from different parties. They're not happy with the judgment. Even some Nigerians, as expected, also finding some shocking questions. They just thought it seems that the way it is in this country, it will be very difficult to prove any case against any president who wins election in this country from the look of it. That's what some persons believe, having listened to that judgment. I know the APC, of course, will be happy about this judgment, and they think that this is going to go.
We worked for victory, and we got the victory, and those who didn't do their homework well expected that recruiting social media mobs to intimidate and overwhelm the court will make the court do the unjustifiable. And if you look at the judgment, every reasonable person, particularly the lawyers, know that the court, in writing a judgment, must base its findings on evidence which have been supplied by those who go to court to seek for one judgment or the other. If you refuse to do your work and you expect, for instance, the judgment in several parts of it alluded to the fact that the people who came to appeal refused to bring evidence, substantial evidence, to the court. If you say that you have been shortchanged in an election, it is about figures. The court will expect you to come to court, bring results, physical results, from any of the 133,000 polling units, to say that in polling unit A, this is the result that was given at the time of election. This is what INEC posted for me. And the court will be able to compare. Merely criticizing INEC is like making INEC the whipping boy.
But what do you think about, because before that election, there was a lot of commentary from INEC themselves about BVAS, IReV, how they raised hopes of several persons that, look, you will see the results wherever you are, it will come through. Then came the presidential election, and people thought, we didn't see what you told us.
It is about figures. You are supposed to have your agents in every polling station.
No, I'm talking about the IReV.
The IReV, the courts have said that the law on INEC, the law which guides INEC operations, did not make it mandatory for INEC to utilize BVAS or IReV or whatever. The law, that's the finding of the court.
I'm sorry, if I will just...
Mr. Gidado seems to disagree with something.
Yeah, but I just, before I come to you, Mr. Gidado,
okay.
The court said it's not mandatory for INEC,
Yes,
right?
yes.
But the court also said it is up to INEC, going by the Constitution, to decide on how to...
And they decided.
Yes, yes. And INEC over and over, prior to the elections, kept saying the BVAS and the IReV is mandatory. That's part of their guidelines.
Yes, they did say that. For whatever reason, perhaps they discovered that they were not compared.
So is that not moving the goalposts in the middle of the game? It is
not about moving the goal. We are not guided. The court has said that the election is not guided by whatever regulations outside the law.
Okay, let's get to Mr. Gidado. Mr. Gidado, the law says INEC is at liberty to decide how it wants to conduct the election. And how to transmit its results. And INEC came out with a guideline that they're going to use.
Very well.
But the justices have said that, from what the teacher has said, the justices have said, it's not mandatory. So some argue that this is like INEC moving the goalpost in the middle of the game.
Very well. Now, I'm happy there's an agreement here that INEC was given the go-ahead to make guidelines based on the Electoral Act, the new Electoral Act. Because the new Electoral Act differs from the old, the 2011. The 2022 Electoral Act now says INEC, under Section 47(1), we've given you the leeway to make guidelines on how to conduct the elections. Now, and in doing so, in their Section 137(1) of their guidelines, INEC said the following procedures shall be followed as far as these elections are concerned. And the word shall connotes compulsion. In other words, you do it, and you were being guided. INEC wasn't just given an unfettered power. They had to be guided by what the law says. Hence, whatever they were to do has to be in line with what the law says. And they were the ones that came out and said, this is how we're going to conduct it, by the use of BVAS and after the snapping of the Form EC8A, it's going to be transmitted real time. And Nigerians will have the privilege to compare what was snapped. Those that had the opportunity to see the Form EC8A would also view the portal and look at and compare. And if the results tally, if you are told you've lost the election, you have no option but just to accept.
Okay, let me, because I mean, journalists in this country spoke several times with officials of INEC on this same BVAS and IReV. They were here, they demonstrated what to expect. In fact, let's just even refresh our memory. I know we heard it time and again where the chairman of INEC was speaking about what to expect to the international community on this. Just have a listen to this.
The second thing we are going to do, and pretty soon, is to conduct mock accreditation exercise nationwide ahead of the election. We won't wait until the main election comes. We'll test the integrity of these machines with real live voters in selected polling units across the country. We did so in Ekitan Osho. It was fantastic. We are going to do so nationwide. And increasingly, you know, our people are becoming even more excited about the deployment of this technology. So we are really happy. And in terms of the numbers of the BVAS machines, we always make provision for additional numbers of machines in case of malfunction or glitches. And there is always a backup. We have what we call the RA technical support that will fix the machines in the unlikely event of any glitches. And where it needs to be fixed is fixed, but where it fails to function completely in a polling unit, and from previous experience, there are isolated polling units, the law has a remedy that the commission should immobilize and conduct the election in the affected polling units within 24 hours.
So that's as clear as daylight.
You see, we have said it earlier. There's a law in place. It compares certain things. It does not compel other things. If those who went to court haven't had their results from the 133 polling stations, if they could have come with those results, had copies of the results, to compare what eventually INEC released. If they did that, the fact that, because use of IReV or whatever, I mean, it is about mode of, transmission of results, not about the quality or standard or status of the result itself.
Doesn't that affect, doesn't the way you transmit the result affect the mode, the quality of the result?
You have to come and tell the court how it affects it. It's not for the court.
Okay, but clearly, I mean, you've seen that and you agree that INEC, yes, they were going to do all of that.
They said they were going to do it. For whatever reason, they didn't do it, but the law does not provide a punishment for not doing what they said they were going to do, insofar as the law did not make it mandatory. What is mandatory is about the physical, writing of the report and collation.
Okay, so INEC...
And for anybody, if INEC came out to say that Mr. A won an election based on certain figures, okay, anybody to contradict that must bring a different set of results.
So it suggests that you're saying INEC took advantage of when the law says there's no punishment for them not doing what they were supposed to do.
It is up to them to do whatever they can justify within the ambit of the law. And I want to give them the presumption of good faith. They were talking of bleach, they were talking of some other things.
They said
this is about technology.
Prof, yes.
Yes, let me come in here. Elections are not Fendi. Elections are not Gucci. Elections is a very serious business. Now, a situation where you came out and told the whole world and the citizens of the country that this is how elections are going to be conducted. And you spelled out, you gave all the parameters of how the results will come out. Now, if, for instance, on the election day of the 25th of February, 2023, 3 elections were conducted: House of Reps, Senate, and Presidency. The House of Reps was transmitted successfully. No issues. So if you look around in the entire country, if there are contestations in courts, they are not contesting because they have issues about the way the results were transmitted. The law was followed there, no problems. Senate, ditto. But when it came to the presidency, they now claimed there were glitches. What sort of glitches are you talking about? Is that human error? And that's the question with the PDP and its presidential candidate challenged, because the law says there must be substantial compliance with the Constitution, with the Electoral Act, and the electoral guidelines before a result can be taken to be credible and legitimate.
Mm-hmm. But part of what he's saying, yes, which I think part of what the justices also ruled, is that even if that were the case, if the petitioners don't prove it, what do you want them to do? If it's not if they say that if that non-compliance, if you don't show us how that affected your results, what do you want them to do?
Oh, as far as the PDP is concerned, we did adduce evidence in some areas where we felt the results were changed. And they were all proffered. The states, the 8 core states were all stated. And even the evidence, the boxes were brought, and it was all presented before the courts, as far as that aspect is concerned. But we have over 7 grounds, or we had over 7 grounds, as far as this the challenge of this presidential election results are concerned. So, but that is just a part of it. That aspect of the non-compliance with the provisions of the Electoral Act and the electoral guidelines as stipulated by INEC itself. So that's one of the first grounds that we thought the Court of Appeal, the tribunal, will be able to give that guideline, that judgment that will assist future generations.
You know, Prof, the question Chimlin asked, and I want to stay with that a bit, where the court says the parties, the petitioners were not able to prove the unreasonable, that certain things were not done properly. For instance, one of the grounds was that the PDP alleged that there was violence and snatching of ballot boxes, and justices said, did not prove the unreasonable.
Nobody came out.
So there was no evidence
was
to prove the unreasonable doubt that these things actually PDP alleged. At that point in time, are you saying that the justices were not able to see, you said adduced evidence in some place, and you had enough boxes for all of that. But that obviously wasn't
with due respect to my
witnesses were also invited.
No witness from any polling station was invited.
No, you weren't there.
You see,
so don't just
to assist you, perhaps.
I'm a counsel.
Yeah, I give you I congratulate you for being a counsel in such a high-profile case.
Thank you.
The thing is, number one, INEC is not the lawmaker. INEC does not have any role of making law. That is one. Number two, we have an election where there were 3 frontline candidates. One scored 8-something million, another one scored 6-point-something, another one scored 6.1. These are figures. The man who was declared on the basis of the fact that he scored the highest number of votes of the 3. If anybody is going to court to disprove it, you have to be able to bring more votes, more figures, higher figure than the man who scored 8 point whatever number of votes. Merely making claims, with due respect, my learned, senior advocate, is not enough. My lord, my learned, you know very well, we are all lawyers. And we know that it is often stated that he who asserts must prove. Atiku is saying he ought to have been declared. Labour Party man said he ought to have been declared. Even between the two of them, they must give figures to show who among them has a higher vote to compete with Tinubu.
Mr. Shitu, let's allow Prof to talk to us about this evidence matter. The justices have given their ruling, and of course, you and your clients have said you're going upstairs. But that matter of, I want to read it here. Justice Samani held that the PDP's allegation of violence, ballot box snatching, did not provide evidence, provide videos or evidence that the allegations were criminal and ought to have been proved beyond reasonable doubt. So you say that the evidence was there. Are you implying that it wasn't looked through?
That is our point. Because, as I said, witnesses were invited. People that were polling agents, people that were supervisors at polling units, and they came with graphic evidence of all the electoral malpractices. And we laid it bare before the court. They were cross-examined. The witness, the exhibits they tendered were accepted in court. But upon all this was what the judges came up with. And that's the reason why we have resolved, or our principal has resolved, we go upstairs. The beauty of it all is that that's not the final court. So we ought to get to the Supreme Court and get the pronouncement of the Supreme Court vis-a-vis the evidence, the avalanche of evidence that they were provided to prove. There were instances, for instance, where we brought the EC from EC 8As, where the figures were doctored. You would see the APC result increased, PDP results reduced, for instance. A Labour Party result also mutilated. So all these boxes that were brought were filled with this evidence, pieces of evidence, indicating the results were tinkered. And we now said, and some of them were also related with the results from the IReV. They differed. What was from EC8 differed substantially with what was found on the IReV. We itemized all this and then calculated. And mark you, there was even an admission by the INEC and the APC that PDP won in 21 states. It's stated there. It's there in one of the reports and the piece of evidence that was tendered before the tribunal. So we have all this evidence, it's proved. And that's the more reason why we are relying on the fact that on appeal, all this will now come up and we will get to hear from the Supreme Court.
Mr. Shitu, let me read this statement from a lawyer about his perception about, you talked about some witnesses providing all of this. You want to respond before I go ahead?
Well, before you go, I am happy that we had 5 justices of the Court of Appeal. And all the 5 from all parts of this country agreed that the case of the petitioners lacked merit because they couldn't prove all essential ingredients to the satisfaction of the court and of the law. So, and Prof is saying something different. It is either the justices, the 5 justices, with due respect to them, are telling lies, or Prof and his team are telling lies.
Now, this statement says, first, on the holding that the witness statement of an unwilling subpoenaed witness must be front-loaded and filed along with the petition. The Court of Appeal was merely enacting a factual impossibility, which has invariably resulted in a miscarriage of justice, with the resultant striking out of critical, oral, and documentary evidence of petitioners' witnesses. The petition must be filed within 21 days of the declaration of the result of the election. Within those 21 days, the panel which will issue and sign the subpoenas wouldn't even have been inaugurated. How then do you compel the INEC chairman or REC to donate to you a witness statement on oath against his wish without a subpoena ordering them to do so? And he cites the applicable legal maxim, which just says that the law does not punish a person for not doing what he lacks powers to do.
Well, they can come up, and I know they are coming up with all kinds of arguments. I'm happy that they are going to the Supreme Court. I'm also happy that under the law, they cannot provide at the Supreme Court any evidence that they refuse or neglected to provide at the lower court. Because at this level, at this stage, I am from APC. Obviously, my prof is from PDP. So, and we have a judgment which favors us, which does not favor them. Being dissatisfied, they want to go to the Supreme Court. In support of the judgment of the 5 justices of the Court of Appeal, we would go and meet them at the Supreme Court.
We've since been joined by Professor Paul Ananaba, Senior Advocate of Nigeria. He part of the team for Labour Party. Good morning, and thank you for joining us on the program today. Well, part of what was read yesterday on the day is that the justices, the court, did say that Labour Party, the petitioner, couldn't prove that there was manipulation across the country, because he also cited that, look, if there was any such manipulation, he favored the Labour Party candidate, and so among several other things, including the petitions that were struck out. And so in a unanimous judgment at that, so many wondered how this was the case, how the petitioners in that consolidated petitions couldn't prove their case.
All right, thank you. That's the opinion of the Court of Appeal, and we respect their opinion. That's their assessment. They have done their constitutional duty. We do not agree with their resolution of those issues, and that's why you would have known that our principal is willing to challenge those findings at the Supreme Court. I am not the Supreme Court, and I'm not going to sit on appeal over the decision of 5 justices of the Court of Appeal. We appeared before them, we presented our case. There's a wisdom in the laws of this country, the Constitution, saying if you do not agree, you should challenge such findings at the Court of Appeal, at the Supreme Court. And that's what we are busy looking at and doing now.
But, yeah, go ahead.
Yes.
I was going to ask that some even thought that, push comes to shove, you will have at least a dissenting judgment. But in this particular case, that wasn't the case. In fact, one of the justices even cited the quote-unquote, the social media perspective on this matter, that were they trying to ambush the judges or put pressure on them to compel them to go in a particular direction?
Again, bringing in the social media angle and all that, those are part of the things we are going to canvass at the Supreme Court. But the point I've been made is that nobody says how a panel will go. Before that panel, it took over a month for that judgment to come. And you are not privy to the conferences of the justices and their individual arguments and how they were able to come up with the judgment again. So those are of the same issues. What we are concerned with now is what they have come out with. There's something wrong with analysis of the social media or the other media or other individuals.
All right, well, Professor Gahadu, let me ask you, because help us shed light on this, because we've heard people say that there were loopholes and there were technicalities and the likes, and then some other persons thought, but there are senior lawyers on both sides, on all sides, as a matter of fact. They are aware of the loopholes, they are aware of the technicalities, so they can't cite that as an excuse. They should have done their homework to at least prove their case beyond reasonable doubt, as they say.
Yes, Chamberlain, let me come back to some of the aspects of these technicalities for instance, refers to this issue of subpoenaed witnesses. Now, a subpoenaed witness is a witness that cannot be invited willingly, to come and testify. You have to subpoena him. The court has to order him, to come. And an example is the chairman of INEC. So for us to have him come to court, it has to be by means of a subpoena. And to get his statement on oath and file it all within 21 days. It's not possible. So the court allows you to bring him in at that time via that court order, and he comes and then testifies before the court. So we were miffed when we had the ruling or the verdict of the Court of Appeal. And it's one of those aspects that we are also appealing against when we get to the Supreme Court. Because as it is now, we are just relying on what we had in the court. This CTC of the judgment has not been given to us in the chambers, but we are expecting it this morning. We would go through it elaborately. These aspects of technicality that you also mentioned. Now, a good example that you can cite is on this aspect of the 25%, in the FCT.
Yeah.
Yes. This is a constitutional provision. The Constitution spelled it out that for a candidate to be qualified to be declared as a president of the Federal Republic of Nigeria, you must satisfy these three conditions. One, in the event that there are two or more candidates, you must have secured the majority of the votes cast. One. Two, you must have gotten not less than 1/4 of the votes, that's 25% of the votes cast in not less than 2/3 of the states of the Federation. 2/3 of 36 is 24. And it concluded with saying, and the FCT. Now, when you talk of and the Federal Capital Territory, there are so many Supreme Court decisions on the meaning of that word and, which is conjunctive. And when read conjunctively, it means the candidate has to secure 25% of FCT. And there are also Supreme Court decisions before that. The case of Buhari against Obasanjo, 2003, and Buhari against Yaradua, 2008. What the Supreme Court said was that you don't need to win, but you ought to get 25% of the votes cast in the FCT for you to be a president of the Federal Republic of Nigeria. And the logic behind it is simple. The framers of the Constitution, I guess, don't want a president to come in where you will be the person to administer the FCT through your ministers, for you to be a tenant. At least let that be like just as a state governor. What the Constitution says, for you to be a state governor, you need 2/3 of the local governments, 2/3 of the votes of 2/3 of the local government councils within your state. So it's the same logic. As the administrator of the Federal Capital Territory, you need at least 25% votes of the people residing in the FCT. Mark you, FCT, people maybe look at the Federal Capital Territory being like as small as it was when it was first established in 1991. As it is today, the FCT is bigger than Bayelsa State. So that is the logic. And when lawyers, adduced evidence to prove that this is what the Constitution says, and the tribunal comes up with a saying that you don't need, to get 25%. Where we will not
colleagues in Lagos.
We'll wait when it gets to the Supreme Court.
And
the disagreement between and amongst members of the bar and bench on the conjunctive and disjunctive nature of that portion of the Constitution doesn't help matters because we don't know if it has been decided conclusively following this tribunal judgment, or if it will still be represented at the Supreme Court level, and whether there will be an alternative view to that, or the Supreme Court would affirm the position of the appeal court, the Presidential Election Petition Tribunal, on that one. But let's follow up on the conversation, particularly on other areas of the rulings of the PEPT. Let me come to you, Professor Ananaba. The tribunal also touched on the issue of non-gender of the PDP candidate who came second and wondered how Obi and LP's petition could be effectively determined without joining the candidate who placed second in the polls. Professor Ananaba, do you think this would have, how did your team miss out on this in the first place? And do you think this would have significantly impacted on the outcome of the judgment in your favor? Maybe not on all of the petitions that you presented, but at least on this front.
Thank you. I am a counsel in that team. So I have to choose my words and my perspectives. I'm not going to go all the way with beginning to argue the appeal that we are heading to the Supreme Court to do at this platform. But the point to be made is the Electoral Act specifies who a respondent in a petition will be. And the Electoral Act also says those who are not necessary parties in an election petition. Time there was when you will find that respondents in an election petition will be 200, 300, 400, 500 persons. But the Electoral Act has stated that you are limited to the persons who were declared. It's not a free fall. It's a sui generis proceeding. So it is one of the issues that we will take up to the Supreme Court. How will you defeat a petition, for example? Is it proper? Is it correct to defeat a petition on grounds of non-joinder when the person who was declared is made a respondent? It's just like when INEC is a respondent, every other person who did whatever it is, who is deemed an agent of INEC, and you don't need to begin to bring the polling agents, the SPOs, NCOs, and all that. So we didn't miss out anything in our petition in that regard. It was the contention of the second and third respondents in that petition. It was a contention, that we should have joined PDP and Atiku Abubakar. We don't think that is correct. We believe that our petition was competent and well constituted, and we've noted the opinion of the decision of the Court of Appeal. We will test that at the Supreme Court.
Professor Ananaba, if you say you'll test that at the Supreme Court, don't you think the Supreme Court will rule that it's an issue that ought to have been presented at the court of first instance and it was not, and hence it cannot rule on it?
No, you challenge decisions. You challenge the findings and holdings. So that's a finding. The Supreme Court will have to look at it whether our petition was well considered in terms of the parties. And precedents are being set. These precedents are important. It's just that the CTCs of the judgment of the Court of Appeal is not out. It's just that it's not out. There are decisions of the Supreme Court, of the courts, that you are limited to the provisions of the Electoral Act. The Electoral Act never said you should join other persons beyond the statutory. I believe I heard the Court of Appeal saying that the statutory parties. The statutory parties are there in the Electoral Act. They are the persons whose declaration we are challenging. And we went the whole hog of even joining the vice presidential candidate there, who is the vice president now. We went that far.
So we have lost connection through to Professor Ananaba, but you know, we're expectant on how the Supreme Court will rule on that one, following the decision of both candidates of the PDP and the Labour Party to head to the Supreme Court. But Professor Shitu, let me come to you now. It appears as if the argument on the burden of proof and the need to argue beyond reasonable doubt is unending. And Mr. Gidado has touched extensively on, you know, what was presented you know, by their candidate and their team at the Presidential Election Petition Tribunal. And I recall also one of the justices also touching on some television stations who acted as witnesses during the trial. And we can even also recall so many television materials during the live coverage of the election that showed, you know, BVAS machines destroyed, ballot boxes, you know, thrown away, carted away in some instances. Don't you think with the presentation of that, it proves, it creates room for reasonable probability of doubt on the outcome of the election, even if not beyond reasonable doubt, and hence the tribunal court ought to have considered it?
I have no reason to think that the tribunal did not consider it. As of today, the law is the judgment of the tribunal. Whatever they have said is true until the Supreme Court reverses it. You know, so I think that is enough for now. I just, before I leave, you know, with due respect to my dear Prof here, he mentioned about 25% of Abuja. The implication, because we must be very careful not to mislead the public listening to us. The implication of the argument of my dear Prof here is that if you have 24% in 36 states, I mean 25% in 36 states, and you have majority of votes, once you did not have 25% in Abuja, all the 25% of your 36 states go to no issue. With due respect, it simply does not add up. It simply does not add up. The people in Abuja are not superior to other people elsewhere. So I believe in the next 2 months or thereabout, you know, the Supreme Court would affirm every statement or finding of the appeal court.
Well, Professor Gidado, I'd like you to respond to that, because those are the exact words of the justices of the PEPC, saying that, look, as far as we are concerned, the voters in a particular location are not in any way superior to the voters in other parts of the country. How do you respond?
Yes, my response to this issue raised is that we are not saying residents of FCT are superior to all the rest parts of the country. Rather, what we're saying is that they are to be seen as equal to anybody in the country, but it is a constitutional provision. So if there's a problem with that, then we just have to find a way of amending the Constitution to remove that phrase and the FCT, which was the situation under the 1979 Constitution. 1979 Constitution never had they never included that a candidate has to secure 25% in the FCT. It just ended with 2/3 of the states of the Federation, period. But so long as the framers of the Constitution included that phrase and the FCT, the conclusion is that you have to secure 25% in the FCT for you to become a president for you to be declared. Because if you look at it, President Tinubu is the only president that has not gotten 25% of votes cast in the FCT since the inception or the creation of the FCT in 1991. Beginning from MK Abiola.
Just a second on that one, very quickly, before we take a short break. If you can hear me, Prof. Just 1 second. If you can hear me, Prof. So what then does the marry this? Because the justices said during that ruling that the FCT should have been treated like it's the 37th state. And I also recall, I think it's section 299 or so of the Constitution that says that the FCT should be treated as if it were a state. So if you can just do that in 30 seconds, marry those two particular, facts with what you're saying right now.
Yes. When the Constitution said in section 299 that the FCT is to be treated as if it were a state, it was talking in terms of administration of the FCT. As far as the judicial, executive, and legislative powers of the FCT is concerned, when it comes to administration, it should be treated as if it were a state. When you say something is as if it's another, it means it is not. So the FCT is not a state. It is a special area carved out. It's also different from Lagos. When we had Lagos as a capital, Lagos was both a state and a capital of the federation. But by the time we now
just 1 second, because we need to take a break now to take a few messages. But just to want this final thing on that Constitution, that section 299 says the provisions of this Constitution. It didn't speak about administration there, but hey, I'm not a lawyer. Maybe that's just one of the perspectives. But there's more on this conversation when we return from this break. Just stay with us. Thank you for staying with us. Professor Nanaba, let me come to you. One of the presidential election court justices, Justice Moses Ugo, said concerning the petitions, and I quote, "At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agreed that they have agents in the polling units?" That's one of the grounds that, it seems that's one of the grounds upon which the justices based their decision.
Well, again, those are part of the issues we are going to challenge. You were aware that we informed the PEPC that we had applied and obtained ex parte orders of the tribunal to get certified true copies of the results, and we didn't have that. It was back and forth with INEC at the tribunal. We eventually got some results. Now, in terms of the jurisprudence as of today, and like I said, I didn't want to start some of these analysis in terms of making so much comments when the certified true copies of that judgment is not with us. By section 137 of the Electoral Act 2022, which is a legislation that is expected that the PEPC would have deepened. It says it will not be necessary to have oral evidence as we used to have, polling unit by polling unit proof. The case of Arebo Shola and all that laid Ocha, case and all that are there. There's a reason behind the purposive interpretation on section 137. Now let me ask, if we were to call polling unit agents, over 176,000 polling units in Nigeria, let's even say we want to call for half of that, 80,000 polling units. How many years will it take us to prove the presidential election? So I'm not going into details of it, but I'm giving you an idea that the legal team at Labour Party knew what they were up against and met it. We tendered results. We showed issues of no results, absence of results, and all that. Fair and good, the Court of Appeal had taken a position. This will be going to the Supreme Court. Like I said, in a contest, the court will not speak from two sides. So the court has taken one side, and we're looking at it. We are going to present arguments for a review at the Supreme Court and believe that the Supreme Court will be more dispassionate, be more detailed, be more careful in analyzing that. And let me make this point here. These petitions are not about President Tinubu and Alhaji Atiku Abubakar and Mr. Peter Obi. If we focus on that, we will miss the point. These petitions are about precedents. They are about Nigeria today and in the future. In the course of discussions, I was hearing Buhari and Obasanjo, Buhari and Atiku, Buhari and these were presidents that were said before. And under the Electoral Act 2022, these are precedents we are beginning to lay. So let's not look at it because we are looking at the president Tinubu, or we are looking at Mr. Obi or Alhaji Atiku. Let the courts come to precedents that will be enduring, that will instill confidence in Nigerians to come out and vote, that will instill confidence in Nigerians to know that if anything goes wrong in the electoral process, the courts are reliable, the courts can be resorted to, rather than resorting to non-judicial remedies.
Okay.
That is what is at stake.
Yeah. Well,
and that's why we're going to the Supreme Court.
All right. Let me ask Professor Gidado the same question, because the Justice, His Lordship further said, I had thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building blocks of election results.
Yes, as far as PDP is concerned, we did produce witnesses. We invited about 27 witnesses, and some of them were polling agents. They came, they testified that they were at the unit, they voted, and they also saw the way people came, used the BVAS machine, and thereafter the transmission took place. And where they now testified the difficulty, for instance, in the transmission. So if you adduce such pieces of evidence, we were taken aback, when we had the tribunal come up with the fact that we never produced evidence, or people never came from the polling units, agents to come and testify. We did that very well. And as was also alluded by my brother Silk, it is very difficult within this short period. Even the 180 days, as far as we're concerned, or I feel it's even too unwieldy, it's too lengthy. I'm one of those that advocate that the duration be reduced in such a way that Nigerians will see a president being sworn in without any legal issues pending. So this wasn't the case up initio, but with the reduction to 180 days, within this period, if we were able to produce such witnesses and they came with the evidence, tendered it before the court, I'm surprised, to hear the tribunal turn up with such an assertion. But perhaps it relates to other parties, but definitely not the PDP. It's that the records are there to show. And it's one of those reasons, too, that when we go upstairs, we'll be able to adduce all these pieces of evidence.
Okay. Well, let me ask you, Mr. Shitu, there was something you said the other time, or I think maybe it was Professor, I was talking about the Constitution, the law, and the guidelines. We know that the Constitution is justiciable. We know that electoral law is justiciable. But the guidelines of INEC, which it produced itself and made a promise that IReV was going to be a game changer in the 2023 elections. But as we all know how that went, and the premise upon which a good number of people are, asking a lot of questions. So the question is, are you saying, maybe in law, whichever way, that the guidelines of INEC or the pronouncements of INEC and repeated, confirmation or assertion of its position on IReV, are you saying it's not justiciable?
Well, your guess is as good as mine. But I just want to remind everyone that what is important in election cases with regard to the law is where not doing a particular expected act has substantially affected the outcome of the election. I have said it earlier. We have three, frontline candidates. One scored 8 point something million, two others scored 6 million plus. Anybody coming to offset the one who scored 8 million has the duty on him, not on the court and not on the respondent, to show clearly, convincingly that not using that IREV has changed the results from what was the actual voting pattern. But none of the petitioners came to do that. My learned brother here was talking of, they have about 28 witnesses who came. Not all the 28 were even polling agents. That is to start with. Now, if you even imagine that the 28 are polling agents, in a polling station, perhaps you have an average of 100 voters. So 100 times 200 times 27 or 28 is about 2,000. How would that affect the more than almost 2 million vote difference between the winner and the next, and the next person? How does it affect it negatively to their advantage? So it is their duty, and it is not, with due respect, going to election tribunal is not about sentiment. It's not about emotions. It is as if you are, proving a criminal act where you must prove beyond reasonable doubt. People who voted for a winner will not allow any system which will bring about their votes not counting. If somebody wins, has majority votes, and then you come to say because the petitioners felt there was not enough time for them to prove another. Well, you neglect to do the needful at your risk. So as far as the election, the judgment is concerned, I am very confident that insofar as the petitioners who are going to appeal will not have an opportunity to do what they refuse to do at the trial, it is to their risk. But
Mr. Shitu, if I may...
And I don't expect any different judgment from the Supreme Court.
Mr. Shitu, if I may come in there...
that the tribunal has done in analyzing the trial.
If I may come in there, Mr. Shitu, in what percentage of the states of the Federation would you require those concerns to be established for it to significantly impact on the outcome of the election? And apart from that, shouldn't the burden of proof now in this peculiar case shift from just the alleging petitioners also to the umpire, the one who conducted the election, to establish what it claims to have been the authentic situation?
I believe they have done that. They came with the result in their possession. The people doubting those results did not bring anything contrary to dispute or contradict the result that INEC submitted. What else do you want INEC to do? It is not INEC which went to appeal in court. It is individual respondents, petitioners. If they have petitioned, it means they have facts which are solid enough to persuade the tribunal to think otherwise or to contradict the votes, the 8 million votes. It is as simple as that. We have figures there. It's not about sentiment. It's not about I was overwhelmed or something. No. You are the one coming to say that the 8 million votes of President Tinubu are not valid votes. They are not genuine. Bring the genuine vote.
All right, gentlemen, we need to wind down now. Dr. Nanaba, let me ask you before we go, why do you think that your... okay, I think we lost him, Professor Porter Nanaba. But Professor Gidado, let me ask you, why do you think your principal will have a chance to overturn this at the Supreme Court?
Yes, you know, as far as litigations are concerned, the Supreme Court is the apex court. It is the final court, and it is that court that we have the hope, and our principal has the hope, that with that expansion of about 7 of them sitting and looking at these aspects, one after the other, the issue of the FCT, the aspect of disqualification, which the tribunal, to our surprise, said they were pre-election matters. Let the Supreme Court decide. It will be the Supreme Court, because they are we cited several Supreme Court authorities that said some aspects of disqualification are pre-election, but there are some that are both pre-election and post-election. So this will now go before the Supreme Court, and we are very sure that the Supreme Court will look at it dispassionately, and looking at the avalanche of authorities that were given by them, to the fact that some of these cases are both pre-election and post-election, then they will now give a verdict. So it is for this that the law has to be tested. That is where, as he also said one time when he was interviewed, if you lose at the Supreme Court, where else will you go? He said he will now take the appeal to God. So he is very confident, and we also believe as his lawyers that haven't looked at the pieces of exhibits, evidence, and the authorities we've cited. When we get to the Supreme Court, we believe the Supreme Court will look at this dispassionately and reverse some of the...
What is your impression about the social media perspective when one of the justices also spoke about that? Are they trying to put pressure on the justices?
No, you see, Chamberlain, the problem with this social media thing is that if you look at previous elections where there was no social media, the justices would just, after the cases, the addresses are adopted, matters are now left for judgment. You will just be relying on the television, the radio, newspapers, but nowadays, there is nothing you would do that the social media will not take one way or the other. And there are some of these people handling this social media angle that when you look at their level of education and the way they analyze things, you will know they have the handset with them. Someone in as far away as Oka, and someone as far away as Madagali in Adamawa and Borno State. What control do you have over him? He doesn't know the justices, he doesn't know the rules of the court, and he will just come up with some conclusion. If this judge doesn't give judgment to my own principal, we are going to do this, or we suspect they've done this. So you see, the justices should just shut their eyes and their ears, to some of these social media the postings. That shouldn't serve as a threat, to them, or shouldn't gag them in doing justice to the cases that are before them.
Was that on court record, though, that it was putting the judges under pressure?
No, yeah, some of them, they were surprised that the judges read some of this stuff. Because as far as I'm concerned, if I'm not on a platform and I don't get news, where I know it's authentic. But when you get to hearing some of these gutter social media stories coming and saying, like someone saying he took it to the church and a pastor was praying on each of the candidates, for goodness sake, that stopped me as a judge.
But I thought that, you all say that what happens in the courts of public opinion doesn't affect the cases before the tribunal, the courts.
I understand, but you see, that aspect of the judges feeling as if the entire social media it's like the society generally threatening them and telling them, you must do this, you mustn't do that, and etc., etc. So that was why some of them took it as if, that is, what is that disturbing them, that's worrying them, and it reflected in the judgments that they delivered. So as far as I'm concerned, they took it too far. You shouldn't have, gotten to that extent.
Well, Mr. Shitu, another senior lawyer also writing about some of this matter says that the principle of presumption of regularity of elections and that of the substantial conformity make it extremely difficult to prosecute elections successfully in this country.
Well, people have won election petitions all over the country, every now and then. In fact, only last week.
But not at this level. Not at this level.
At senatorial level, at governorship level, and so on. So it does not mean that it is not impossible. But the truth is, people assume that, based on sentiments, based on emotions, the judges should act in a particular way. No judge worth his salt will just write a judgment without having enough evidence to back up his assertions. He'll be putting his job on the line. Because even judges have, people who superintend over them at a higher level, at the Supreme Court level. So, it's not as if, but in truth, I want to believe that it is the same people propping up attacks on social media that were also responsible for billboards on, all eyes on the judiciary. It's the same people.
There's no proof there, is there?
Well, there's a presumption because, they were working...
But not substantial proof.
Well, so if there was no substantial proof, the fact of its existing in our daily lives in this country makes it of great concern.
But how does that put pressure on judiciary?
Of course, they have said it. Of course, they have said it in their judgment that...
No, but they didn't refer to that. Wasn't social media. That was above the line outdoor advertising.
I am just saying that the issue of social media, the judges, said they would never be intimidated by. It is good for the purpose of us knowing as a country that when you have a case in court, it is better you look for a credible evidence rather than rely on sentiments, emotions, and campaigns of calumny.
But doesn't that suggest that, look, they don't, justice, whether it's seen to have been done or not, might be immaterial. Some may interpret it that way.
Well, anybody who wants to make, something out of it, since they are going to Court of Appeal, let's see. Since they are going to Supreme Court, let's see what comes out of that.
All right, Mr. Adebayo Shitu, former Attorney General and Commissioner for Justice for your state and former Minister of Communications. And then Professor Maxwell Gidado, Senior Advocate of Nigeria. We also had the pleasure of hosting Professor Paul Ananaba, also a Senior Advocate of Nigeria. Gentlemen, thank you all for your perspective today.
You're welcome.